So, kindly note that Canadian Constitution gave us the idea of having a strong center. Uh, we are not a federal kind of a legal system. A lot of jurists believe that we are quasi-federal or semi-federal, because we are not saying only the central government is powerful. The state governments are also powerful in their own respects in the subjects that are allotted to the state. Those states have their own ability to govern. Please note, the states in India don't have a constitution to themselves. So they're not independent. And please note, as I said earlier, that India is not a union of states. It's kind of a federation where states have their governance, and the center can always dominate and take over state governments if required by imposing precedence rule or others. And most importantly, in terms of the strengthening of the federation of the central government, I think any kind of residuary power, this is important, because what the Canadian Constitution says is that the powers that are not mentioned in the Constitution, because the Constitution probably cannot envisage all the powers at the time when it is enacted. There could be several that could be required to be brought about at a later point of time. So residuary, or what is remaining, is always with the central government. So central government can introduce something very unique, either in taxation or in governance. For example, taxation, we introduced something called service tax very late under the Finance Act. It was not existing when the Constitution was there. Or it could be something on, say, a residuary power, that is, if there is an international convention or a treaty to which the central government has to give enforcement, then that power to make a legislation to fulfill its commitments under international agreements or treaty is with the central government. Right? And the Canadian Constitution from the Canadian Supreme Court also brought in what is known as the advisory jurisdiction of the Supreme Court. Now, the advisory jurisdiction of the Supreme Court is very, very important, quite rarely exercised but used quite often whenever required. And one of those examples of the advisory jurisdiction of the Supreme Court was in the 2G case, when in one of its earlier decisions, the Supreme Court did mention that auctions shall be the only process of resource allocation in the country. And the government, found it very difficult to complete the obligation by the Supreme Court of India, to which I think the advisory jurisdiction was sought. And then the Supreme Court did say, in its advisory jurisdiction, saying, rather a clarificatory note saying that, it shall not be mandatory, but it is the most preferred method of auction. The advisory jurisdiction, on the other hand, so these are ways in which you go back to the Supreme Court. But advisory jurisdiction is when the government or the President of India requires legal advice on certain constitutional matters, and the Supreme Court, being the final word on the Constitution, probably gives those advices as well. We should get into this a little later, but I think just giving you an idea of, apart from adjudication of disputes or determination of rights, the Supreme Court has other functions as well, and the Canadian Constitution gave us all that. So these were constitutions of the world that were there existing before India, and that helps, isn't it? The Australian Constitution gave us concurrent list, freedom of trade. German Constitution, which I think is very, very patriarchal in terms of what it says, gives emergency power. Soviet Constitution gives the idea of justice, mostly social, economic. The French Constitution talked about our republic, the idea of liberty, equality, and fraternity. South African, how to amend the Constitution. Japanese Constitution, procedure established. So I think all of these constitutions were studied. So I think to a larger extent, the Indian Constitution is the comparative best of the world Constitution. I repeat, the Indian Constitution is the comparative best of the world Constitution. And probably because we wanted to give ourselves the best Constitution, our Constitution became a little, longer, bigger, and broader. And I think a country like India, which is so challenging in terms of the topography and others, so many castes, religions, ethnicity, so many tribes, so many kind of challenges. I think this Constitution was something that we had to give to ourselves, and probably it could be one of the best constitutions because it has the best from the world. This is the photograph of the Constituent Assembly that was formed in 1946. It was supposed to be a sovereign kind of country that was attempting to draft the constitution, so we had to make the same. So the Constituent Assembly, I think, is an important player because they spent about a year trying to give us a constitution. So I think they spent a lot of time in doing the same. And if you notice that the Constituent Assembly had different committees, and there was a drafting committee, there was a minor committee, and there was a major committee. And the major committee, especially on union powers, was headed by Jawaharlal Nehru. Then you had so many other committees that were advising the Constituent Assembly. There were minor committees including finance and others. So major and minor, they are divided so that each person takes care of whatever is required. And then we had the drafting committee. And the drafting committee took actually 6 months to draft the constitution after the Constituent Assembly had debated the entire process. And the drafting committee, of course, was headed by Dr. B.R. Ambedkar. He was the chairman of the drafting committee, and we had other members, including N. Gopal Swami Iyengar, Aladi Krishna Swami Iyer, Dr. K. M. Munshi, Said Mohammad Sadaullah, N. Madhava Rao, and T. T. Krishnamacharya. These were the members of the drafting committee. Dr. B.R. Ambedkar introduced the final draft of the constitution in the Assembly, Constituent Assembly, on November 4th, 1948. November 4th, 1948 is important because the first reading of the draft started. The second reading, clause by clause, started on November 15th, 1948, and it ended by October 17th, 1949. During this stage, during 1948 to 1949, as many as 7,653, that is 7,653 amendments were proposed, of which 2,473 were actually discussed in the Assembly. And finally, friends, you notice that the Constitution was adopted on November 26, 1949, and November 26th is generally considered as Law Day or Constitutional Day, because that is when the Constitution was adopted into this country. And when it was adopted in 1949, it contained one preamble. Of course, the entire Constitution will have only one preamble. 395 articles and 8 schedules. Right now the Constitution has 12, but then it had only 8 schedules. Dr. Ambedkar was probably India's first independent law minister at that point of time. And please note that while we adopted the Constitution on November 26, 1949, the Constitution came into force only in January 1950. That was 26 January 1950. And when we, brought the Constitution into effect on 26 January 1950, that is when we truly determined ourselves to be a republic. And that is when the Republic Day gets celebrated. So that is how the Constituent Assembly came into force, and you will notice that there are some interesting facets of history that some would like to take note of consideration of. Okay. So the Constituent Assembly took almost 3 years, 2 years, 11 months, and 17 days to draft the Constitution. It had 11 sessions over 165 days. So I think quite elaborate in that context. The drafting committee, as I had already told you, the assembly was headed by Sachidananda Sinha. Then it was headed by Dr. Rajendra Prasad. So the Constituent Assembly had a head to manage the debates in the Constituent Assembly. General elections in India were held in 1952, and from 1950 to 1952, the Constituent Assembly acted as the provincial parliament of India. The two houses of parliament came into existence only in 1952. Interestingly, the constitution has been amended more than 100 times, and please note, currently we have 448 articles and 22 parts to the constitution. That's the history of how the constitution came into existence. Now, just to take you a little bit forward, the Constituent Assembly did do a lot of work, but I think there were some criticisms, and of course, in a democracy, dissent and criticisms are quite something that one will have to take with a pinch of salt. And one of the criticisms of the Constituent Assembly was that it was not a perfectly representative body. It did not represent public directly. So it was not kind of a elected body representing the idea of the people. These were basically those who came from different strata of the society, and you will notice that it was not representative of the communities that we had. So that was one very important criticism. You will notice that community-wise representation in the Constituent Assembly, Hindus were around 163, Muslims were 80, and the Sikhs were only 4, Anglo-Indians 3. Indian Christians, there were only 6 in the Constituent Assembly. So people did question this kind of a representation over there. Not necessarily religious though at that point of time. Second, I think one critic is that it was not a sovereign body, so it was still not something that we were completely independent of, where the Britishers actually influencing the making of the constitution in some form is something that and was the British proposal being considered was also something that was criticized. Of course, time consuming. India required a fast process to gaining independence and getting the country running from the clutches of the Britishers. So, taking such a huge amount of time, the American Constitution, it is said that it was drafted just in 4 months. Okay, but the Indian Constitution seems to have taken the drafting just took 6 months. But what happened in the Constituent Assembly and how finally it got into the process, I think that was a major criticism of the Constitution. In fact, Nasiruddin Ahmed, a gentleman in the context and a member of the Constituent Assembly, said this is like a drifting committee, not a drafting committee. Because it was drifting committee. Of course, I think the major criticism of the Constituent Assembly is that it represents majorly only one party, that is the Congress Party or the Indian National Congress at that point of time. And most of the members of the Constituent Assembly were politicians or they were lawyers. At that point of time, we always meant that lawyers were de facto politicians and politicians required to have a law degree. So it was only so, the Constitution looks like a heavily legal document than anything else. Maybe because of the dominance of lawyers and politicians in the Constituent Assembly. So I think the criticisms can be, I'm sure, at that point of time, whatever was the best that could be done with the best of people who could be assembled to be part of the Constituent Assembly. And I think having 292 members to the Constituent Assembly is not a bad idea. The princely states were also given their due. That also, I think, was fairly done. But if they did not take part, I think that is their responsibility, and I don't think there is anything particular different that India could have done at that point of time. So I believe that it is in that context of the time and the circumstances, the economic capacity of the state, the social and political challenges and turmoils that were happening at that point of time, the challenges of dealing with Muslim League, which did not want to take part, they wanted a partition and the separation. I think keeping all those into consideration and being fair to the Constituent Assembly, I think they did a fantastic job in giving us this constitution, and I think it's a kind of occasion on November 26th, which is called the Constitutional Day, to actually celebrate, acknowledge this, this date in history to which we got this constitution. Now, some final facts that may be of interest to many of us is that the Constituent Assembly, we were quite creative in trying to have a symbol for our activity. It shows what the what the Constituent Assembly believes in. So elephant, you will notice, was the symbol. It was like the seat of the Constituent Assembly. Sri B.N. Rao was appointed as the legal advisor to the Constituent Assembly. S.N. Mukherjee was the chief draftsman. Right. To be honest, putting things in legal language and legal words also becomes a very critical aspect. And Prem Bahari Narai was the calligrapher. And the original, constitution was actually handwritten by him in italic style. And you will notice that the original constitution was actually written in English. And later on, the translation in Hindi was also made. So it was handwritten, italic style, and some of the original constitutional book is still there in a lot of museums and libraries. Law libraries also have them, and there were people like Ram Manohar Sinha who ornamented the original preamble as well. So I think they created a history by writing this constitution, adopting and enacting this constitution, and I think that is a little bit note on why, how the constitution becomes critically important and how we brought the process of getting us a constitution which then looks at the entire gamut of public administration in a country like India, which currently is a very powerful nation across the world. It is considered to be a nuclear state. It is considered among the top 5 economies of the world. It is among the top populated country of the world. It has probably the largest diaspora across the world, and it is probably one of the richest country in terms of resources, and the richest country in terms of the kind of a historical, cultural matter as well. So I think that should sum the kind of analysis that is required to lay down the pitch to understanding this course.